Tina, we've allowed an hour for the session. All right. Well, welcome everyone. My name is Paul Cubli. I'm the Chief Operating Officer and Group Licensee in charge. And part of CNG Property Group, we are delighted to be presenting you today the Strata and Community Reforms webinar. Prior to starting today's webinar, I'd just like to begin by acknowledging the traditional owners and custodians of the land on which we meet today, the Gadigal people of the Aurora Nation, and pay my respects to their elders past and present. I'd like to welcome Phillip Kooper, the Head of Governance for CNG Property Group, with over 20 years experience there, and Adrian Mueller, a Strata lawyer, JS Mueller & Co. lawyers, with over 20 years of experience and service to our Strata industry. So, gentlemen, thank you very much for joining us today. And part of today's webinar will be covering off the Strata and Community Association reforms that are commenced on the 11th of December. A bit of a bio, again, as the Chief Operating Officer and CNG Property Group and the Group Licensee, I'm proud to be hosting today's webinar with two of our panelists. We all have Phillip Kooper, who is the Head of our Governance at CNG Property Group, overseeing all of our brands. Again, commenced his firm in 2005, just under, but I believe over 20 years experience. And Mr. Adrian Mueller of JS Mueller & Co. lawyers since 2002. I imagine, Adrian, you've seen all these changes and how the industry has actually changed in your time and dealings with many schemes and owners, corporations and community associations. So thank you very much for joining us today and being part of this webinar. So we have today the changes to the strata and community laws. And we're acknowledging the ever-changing landscape of the communal living the New South Wales government implemented to the strata and community laws. These changes have been made to the Acts regulating strata and community schemes, and these amendments were legislated on the 11th of December 2023. How we got there? Basically, obviously, is through New South Wales government undertaking their public consultation in the recent years. It was about changing influence and crucial aspects of strata management and community management, looking at procedures and disclosures and requirements for conflicts of interest, and really regulating concerning day-to-day elements being pets, financial management, and bylaws. There's some transitional arrangements that are in place for certain reforms, and we'll be touching on them as well. Go to the next slide there. So we've got some transitional periods, and in part of the legislation, I understand there's always sometimes provisions of transitional periods for the legislative changes. So to our panelists, I might start with you, Phillip, and go through these transitional period changes that come into place.
Yeah, thanks so much, Paul, and nice to be here, and welcome, Adrian. Effectively, the government made their changes and implemented those in December of last year, but they did identify some areas that have a bit more time to comply. So in simple words, it is a grace period that allows for compliance a bit later down the track. These delays in compliance, or this grace period, is defined on New South Wales Fair Trading's website, and they cover off on three main points. The first one relates to the original owner's obligations regarding providing documentation. The second change relates to the landlord's agent's obligations, and the third relates to obligations to notify of tenancies. On these topics, though, a few comments from our perspective operationally. a lot of these appear to already be covered under the old Act, such as the need to update the strata roll with tenancies. So over to you, Adrian, very quickly. Firstly, are we correct in saying that these changes, whilst documented, are fairly nuanced and perhaps already were in place and just being more emphasised?
Thanks, Philip, and good evening, everyone. Thank you for joining us. Philip, what you say is quite right. A number of these new laws already existed and have existed for a number of years in the strata industry. And what these changes to the legislation do is perhaps place a slightly different emphasis on some of those new laws by teasing out the details of them a little bit further, and in particular, clarifying who's responsible for complying with them. So what we see here on this slide is that one of the new laws, which we'll talk about in more detail in a moment, requires property managers and rental agents to give tenancy notices to owners' corporations when lots that they manage are leased. Now, up until these changes to the law took effect, there was no specific requirement imposed on property managers or rental agents to provide tenancy notices. It was generally presumed that they would be the parties to give those notices, but anecdotally in practice, they are very rarely given. So hence why these more nuanced laws have been introduced to make clearer the obligations of, for example, rental agents and property managers to give tenancy notices to owners' corporations.
And you would say it would be clearing up those sort of grey areas, I imagine, for the day-to-day of a strata management and an owners corporation community association, I guess there, Adrian, as well.
That's right, Paul. So where a property manager looks after the leasing of a lot in a strata building, it's now clear that it's that property manager who's responsible for providing the owners corporation with details of the tenancy or lease, rather than the landlord, even though the landlord is still able to do that. But that clarifies the role that the property manager is meant to play in that regard. Thank
you, Adrian. So we've got some main changes that the reform looked at. And Philip, I mean, we look at, 8.8 is much more, but there's some significant changes here that cover through, starting from the strata renewal process.
Yeah, that's right. So what we're trying to do in the preceding slide was really just outline for you the main topics that we are going to cover. Of course, the eighth topic there was the and much, much more. So these kinds of things can expand. But what we really wanted to do is touch on the main topics as we read them so that we can present to you a more succinct and digestible set of information. And the next point is the strata renewal process. So this is our first topic.
Fantastic. So with the strata renewal process, I think it's one thing that involves the strata collective sales. Adrian, these things can be a little bit technical and complicated at times and being a common element of discussions in our industry. What do you make of these changes that come through for the strata renewal process?
Paul, these changes are a reflection on what has occurred in the industry since these strata renewal laws were introduced in November 2016. And what we've seen in that time is a lot of press attention devoted to them because, of course, these are the laws that allow strata buildings to be sold or redeveloped with the agreement of 75% of the owners. And a lot of media attention has focused on the interests of minority or dissenting owners who are opposed to a collective sale or a redevelopment. What has happened in practice is that quite often people with a vested interest in the outcome of a collective sale or redevelopment have become involved in the decision-making process that an owners corporation must go through before a collective sale or redevelopment can occur. And so what often has happened is that lot owners or strata committee members have in fact been connected with property developers who end up being the ultimate purchaser in a collective sale and have sat on strata renewal committees or strata committees and influenced the outcome of the process. So one of the main objects of these new laws is to require any owners, particularly Strata Renewal Committee members or members of a Strata Committee who have conflicts of interest or pecuniary interests in the outcome of a collective sale or redevelopment, to disclose those interests at an early stage so that owners can become aware of them and act accordingly. And to allow the Land and Environment Court at the very end of the process to evaluate those conflicts of interest, to determine what impact they've had on the process and whether they have resulted in the process being an unfair one, or the deal that's being offered to owners by a developer in, for example, a collective sale, being unjust or inequitable. Not only that, but what we've also interestingly seen over the last 7 years is some property developers deliberately buy into strata buildings with a view to blocking or obstructing the collective sale process. And some of those property developers have in fact become dissenting owners and objected to proposals being approved by the Land and Environment Court because they are trying to get a better deal for themselves and stop the collective sale going through, notwithstanding the support of at least 75% of owners. So what these laws are designed to do is give the Land and Environment Court greater flexibility to penalise dissenting owners who object to collective sales or strata redevelopments in bad faith to further, for example, their own personal interests. And indeed, in court cases involving these matters, that court will now have the power to require those dissenting owners to either bear their own costs for objecting to the proposal in court, or alternatively pay the costs of the owners' corporation. An interesting anecdote, Paul, is that even though these laws have been in place for about 7 years, there is only one reported Land and Environment Court decision where a collective sale has been approved by the court. So that is another reason why some of these laws have now been introduced to make the process a little bit easier. And if you look at the last point on our slide, that point, which allows the Land and Environment Court to overlook technical deficiencies along the way, is an important one, because the way the laws were previously written, if there were any technical flaws in what can be a very time-consuming and expensive process, that could result in the entire process falling over at the final hurdle when a judge in the Land and Environment Court decides that, for instance, the notice of a meeting wasn't properly served on all owners, or proper notice of that meeting was not given to all necessary stakeholders. So this is intended to give the court more flexibility to overlook those potential problems, particularly if it won't cause any significant injustice to any of the owners or other stakeholders.
Thank you, Adrian. It's quite interesting because they look at, revealing any direct or indirect financial or other interests. How would you suggest for an owner's corporation in that regard in recording those interests? Is it an obligation for them to record it within the minutes? Is it best practice in this regard? Because we talk about the process and in that regard, how would be the best practice in your opinion?
Paul, that's a great question. And it's my view that conflicts of interest that are disclosed by committee members ought to be recorded in the meeting minutes to make sure that owners current and in the future become aware of those conflicts, and new owners that buy into the building during the course of the collective sale process have the opportunity to look at those minutes and become aware of those conflicts and allow them to make more fully informed decisions when they're considering proposals that may have been influenced by members of a strata renewal committee that have ties to the developer.
Thank you, Adrian. A very interesting part, and our next slide is going on to pets and assistance animals in that regard. Phillip and Adrian, there's been so much in the media, so much social media in terms of pets, animals, and assistance animals. What are we looking at the changes here when we're dealing with pets and assistance animals? I might pass to you, Phillip, and then come over to Adrian to the bylaw aspects.
Thank you. I mean, the purpose of this slide is just to let you know what the rules are. So it's effectively saying that there is an inability to charge a fee or a bond for a pet being kept within a lot. And the second point relates to the ability of assistance animals to not affect the ability, which again is already covered under current legislation. That's my understanding, Adrian, that you cannot prohibit assistance animals. Perhaps if we move to the next slide, we can talk a little bit more about the pragmatic impact that this has, because the legislation does certain things and says certain things, but the implication to the consumer and the practitioner in this industry is, how does this deal with current bylaws that are registered or current rules that owners may feel they have in place? So I think what would be helpful to the attendees would be to talk about, we understand the rules, we understand what they say you can and cannot do, but how do these interact or impact on existing bylaws that are in place? And I think that would probably be a nice sort of segue. If Adrian, you could respond to that. I have my views, but you're the expert, so I'd like to hear what you think.
Well, Philip, this all came to a head in October 2020 when the New South Wales Court of Appeal handed down a ruling that a bylaw prohibiting the keeping of pets in the Horizon building in Darlinghurst, Sydney was harsh, oppressive and unenforceable. And that created waves through the strata industry, because up until then there were many strata buildings across the state that had in place bylaws banning pets. So that then followed with some further changes to the strata legislation by the government, which in effect codified in some respects the ruling in that case. Now, what was the response of many owners' corporations? Well, the response was, if we can't ban pets, then let's make it as hard as possible for people to keep pets. And what that saw was the introduction of a number of pets bylaws in buildings across Sydney in particular that required people who wanted to keep pets in strata buildings to pay onerous bonds and application fees to their owners' corporations. And that was intended to create a financial disincentive to owners and residents to apply for permission to keep pets. Now, there was a case involving the Elan building in King's Cross, Sydney, where NCAT upheld a bylaw that required owners to pay a pet application fee when applying for permission to keep pets. And so what the government is now doing with these reforms to the legislation is saying that we have a clear public policy of wanting to allow pets in strata buildings, and we want to make it more difficult for owners' corporations to restrict the right of owners and tenants to keep pets in those buildings. So what this now means is that existing bylaws that permit, for example, owners' corporations to charge bonds or pet application fees on owners and tenants are no longer going to be enforceable, or at least they're not enforceable to the extent that they contain provisions dealing with bonds and pet application fees. And what I find interesting as a lawyer is the fact that these new laws, in my view, are going to apply to existing bylaws that have pre-existed the introduction of these new pieces of legislative reform. So there are hundreds, if not thousands, of strata buildings across the state that have pets bylaws that now contain clauses in them that are not going to be enforceable. And so one of the takeaways from this should be for strata committees to immediately take a look at their pets bylaws to see whether they comply with these new laws, and if they don't, to change them.
And I think in saying that, Adrian, when you look at the changes in legislations, owners corporation and community associations are having to revisit their bylaws more and more these days, every time there's a legislative change in having these bylaws and updated, because I believe there is a clause within the Act that, says you can't have a bylaw that, contradicts the legislation in that regard.
That's right, Paul. It seems that over the last 7 years, every time Parliament has changed the Strata Schemes Management Act, those changes have included amendments that impact the validity of bylaws. And in my practice, I've had buildings come to me over the course of the last 7 years on 3 or 4 occasions, asking me to review their bylaws as a result of those changes to the legislation, which is the prudent thing to do, because these changes to the legislation as I indicated a moment ago, are going to impact existing bylaws and result in some existing bylaws, particularly PETS bylaws that we're now talking about, being unenforceable, or at least having parts of them which are not enforceable.
Thank you. I think, Adrian, I still recall the day where there were model bylaws that permitted an animal and didn't permit an animal, and we deal with so many additional clauses and changes through that. Thank you very much, gentlemen, for your input. So going on to from assistance animals to committees, and I'm mindful that we've got some Q&As coming up, and I want to rest assured we will be addressing the Q&As closer to the end of the session to be able to clarify some of those questions for you. But on the topic of committees, now we have a lot of committee members in attendance today, and Phillip, there's some real changes to committees, and I think when we look at these three changes, they vary from conflicts of interest to removal and restrictions on committee. What's your take on these changes?
Well, thank you, Paul. There are significant changes, and the first point talks about the involvement in the decision-making process if there is a conflict held by a committee member. On that first point, I find it interesting, and I would like to hear Adrian's view on this. I find it interesting that the legislation talks about what someone cannot do if they have a conflict, but my reading of the rules are that the declaration of a conflict is initiated, or obligation is on the person who may have a conflict. It doesn't allow for someone else to allege that someone has a conflict. And the challenge here, of course, is that if someone does have a conflict but don't disclose it, would that not mean that this rule is somewhat frustrated because the person who may have a conflict isn't put in a position where they have to disclose it if they don't disclose it? That would be my first sort of comment in a pragmatic sense of the first point. Would you agree with that sort of crude summation, Adrian?
I would, Phillip. It's really a self-reporting system that's been introduced. And as you've correctly identified, the problem occurs when the person with the conflict refuses to disclose that they have the conflict. And the difficult question that then arises is, where does that leave the owners' corporation or the strata committee?
Thank you. I appreciate the confirmation of my thoughts. Now, the second bullet point is very interesting, because under previous legislation or prior to this amendment, the methodology of removing a committee member was through a general meeting resolution passed by special resolution. So now we have a situation where a committee member or members can be removed if a meeting by ordinary resolution votes to do so. So in a fast forward to practical landscape, I would think that this will mean that the frequency of general meetings to do this will significantly increase. That is not necessarily a bad thing, but it's just something that consumers should be aware of, because when the threshold to achieve the outcome is higher, the probability of going through this process is lower. So I think that this will have practical impacts on buildings. I'd ask the other panelists, is that a view that you share, or do you have any opinions on that?
Well, I mean, if they're elected by a majority, I think it's one of the things that it's rescinded or removed by a majority. But it's I find the next point very interesting, gentlemen, when we look at that in terms of who's removed from a strata committee and there being restriction. What's your thoughts on that?
On the final bullet point?
Yes.
I've got strong views on this one, Paul, and that wasn't a loaded question. The interesting thing to me is that the legislation says that they will not be allowed to serve again for a year, but practically speaking, or generally speaking, committee members are elected at every annual general meeting. So in theory, this inability to serve again for a year hasn't been clearly clarified as to whether it's the year from when the resolution to remove them is passed, which is what you would reasonably assume it to be. And the person removed could then be waiting closer to 2 years if the AGM is held at a later time. So I think this is slightly undercooked, and perhaps amendments to the Act might sharpen this one a bit.
What's your opinion on that, Adrian? I mean, it's a valid point that Phillip raises. Is it the next AGM or is it a year from the date of the resolution? I mean, as strata managing agents and owners corporations will want to know, a year serves as 12 months, in my opinion. What's your position on that?
Yeah, my very good points, Paul and Phillip. My view is that the 12 months commences to run from the date on which the resolution is passed, removing the person as a committee member. I think these are good changes. I've been asked to advise repeatedly over the years on the ways in which owners can get rid of committee members they don't like. And the practical advice I used to give was it's going to be very difficult for you because you need to pass a special resolution to do that, which requires at least 75% of the unit entitlement to be in favour of it. And it's very unlikely that would occur unless it's all one-way traffic and everyone dislikes the particular committee member. But strata schemes are meant to be part of our liberal democratic society, and if the majority has voted in a particular committee member, then the majority should be entitled to remove that committee member from office. And I also think that this 12-month embargo on a committee member who is removed from office being eligible for re-election to the committee is a good one because it closes an obvious loophole that did exist in the legislation before that.
Thank you. And just to confirm, when we're using the word a majority vote from the owners corporation, we're talking about a general meeting of the owners corporation. So committees just can't go off and vote off members. It's still a general meeting, an extraordinary general meeting of the owners corporation, for example, in that regard.
That's right, Paul. It's clear that if you want to sack a strata committee member, that needs an ordinary resolution to be passed at a general meeting of the owners corporation. The committee can't itself sack some of its own members.
Thank you, Adrian. So to our next topic and our webinar is the annual general meetings. Now, Phillip, an annual general meeting, everyone knows what an annual general meeting is and how frequently they're held. Once within the corporation or association's financial year. But we've had some modification to the guidelines regarding annual general meetings, consisting of notice periods that must be provided and restrictions, etc. What I might do is, Phillip, I might pass to you first off in terms of those first 2 points covering off the notice period and dealings with original owners.
Thanks, Paul. This is a great opportunity to just reinforce notice periods. The legislation provides for what they call clear days notice. And a lot of our challenges as service providers to the industry is clarifying what this means. So I might just take a moment to do that. Clear days deals with the perceived number of days it is reasonably anticipated a lot owner has the document in their hands. So this includes the postal rule under the Interpretations Act that allows for what has to happen before the clear days start to be counted. So prior to the changes in legislation, the requirement for an AGM was 7 clear days. But before we all get excited about how short a period that is, we have to remember that that is preceded by another set of rules in how you calculate the distribution of that notice. So in plain terms, if even just one owner on a strata roll receives their notices by post, the clear days cannot commence until 7 working days have been satisfied prior, and that cannot count weekends or public holidays. So on the first point, under the previous legislation, it was 7 clear days, which depending on the time of year when the public holidays are, it could range from anywhere from 19 calendar days through to about 23 calendar days. So now they've added a further 7 days to that. Just on that topic, Paul, I know we discussed this earlier, and this really does allow for a great opportunity for consumers to move towards electronic service of notices. So apart from the obvious reduction in environmental cost and commercial cost of distribution. If owners take this as an opportunity to move everyone to electronic service, the extra 7 days can then be rescued, if you like, if you want to have flexibility to hold an AGM sooner.
Well, and Philip, in saying it, so you're basically saying with email service, there's a reduction of a notice period. I think, in opinion, 7 clear days, and you're close to 21 days from the time you get the notice out, because some are served by post there in that regard, and in instance, sometimes it's forgotten about, etc., because of such gap between the time you receive the notice and the meeting. So 14 days, you're basically saying that it's nearly a month's notice now. If we've got to serve an AGM, an owners corporation or a community association serves their notices, you're looking at 28 days realistically to have that notice out. So it's basically a month in that regard.
That's right. And the only final point I'd make on that first bullet point is that the legislation appears to only extend this time for annual general meetings. I couldn't read this also applied to general meetings that were not the annual general meeting, which is interesting to me. But is that a correct understanding, Adrian?
Yes, Philip, I agree with that observation. I think it is. And I think that the shift to 14 days notice for annual general meetings is Parliament's recognition that that's the most important meeting of the year for any owners corporation. So the rationale for extending the notice period from 7 to 14 clear days is to give owners more time to order their affairs, consider the content of the AGM notice, and if they want to do canvassing for support for their position, allowing more time to do that.
And then we've got the changes on top of that with the first AGMs and handing over the essential documentation, these being the original owners. I assume they're meaning the aspects of builders, developers, with being 2 weeks before the initial AGM, being the first AGM. So, Philip, procedure in a good governance sense, when you take that on board, how does that work with the changes?
It just results in the need for better housekeeping for the second bullet point to make sure that these things are received. And I think in any environment where the agent has to champion rules, I think it would be best practice to have motions on an agenda that would acknowledge whether a third party had followed those rules, and to give the client the ability to make decisions as to what to do if those rules were not followed. So, for example, previous legislation had obligations on the documents that must be provided at the first AGM. It's a very nice thing to request it, but what do you do if it's not done? So I think it's good to have a proper motion to alert the consumer of whether that has been satisfied.
I think, and just to say, Philip, I think, in our group, it's been always best practice to receive that documentation prior to the first AGM to be able to demonstrate the records you've received. I appreciate there's 14 clear days, but would you say, in a good governance sense, it would still remain as best practice to have those records before conducting or issuing the notice to the first AGM?
Absolutely, yeah.
And then we've got the provisions of the restrictions on power of attorneys and company nominees that can represent. So, Adrian, I'm just going to come to you there, because you've probably seen this before and had questions arise from owners corporations and strata managing agents. What's your take on the restrictions that have now been imposed upon power of attorneys and company nominees?
Well, this is an interesting change, Paul. It does two things. The first thing it does, and probably most importantly, is that it confirms that a person acting under a power of attorney is entitled to vote at general meetings of an owners corporation if the power of attorney permits them to do so. Now, up until these changes became law, there was confusion, widespread confusion, about what to do when a person turned up to a general meeting brandishing a power of attorney and expressing a desire to vote on behalf of an owner. This now clarifies that. There's no need for that person to have been appointed as a proxy. As long as they come with their power of attorney, they're entitled to vote provided the power of attorney gives them that right. Of course, best practice would be for that power of attorney document to be provided to the strata manager or chairperson well in advance of the meeting to avoid any problems arising at the meeting. But in terms of placing restrictions on how many votes can be cast by company nominees and powers of attorney, this is an interesting one, and this extends the restrictions that were introduced in November 2016 on the number of votes anybody can cast. And what these restrictions now say is that a person who is acting under a power of attorney or as a company nominee can't exercise voting rights on behalf of more than one owner in the case of a small strata building that has up to 20 lots, or in the case of a larger building that has more than 20 lots, more than 5% of the total number of owners. So these changes are designed to further the anti-proxy farming laws that were introduced in November 2016, which did also receive some media attention because a number of strata stakeholders felt that it was unfair that people could turn up to general meetings brandishing a swag of proxies and use those proxies to get their way and have motions approved that on occasion furthered their own personal interests. So this is yet another layer of regulation to make voting at general meetings more fair and equal. But on the flip side, it does have scope to operate in an unfair way, particularly when company nominees should be entitled to represent more than one owner because, for example, there is more than one company that they have been appointed the company nominee of to vote at meetings. And the way these legislative changes have been written, it's not clear that in those circumstances, the company nominee would be entitled to vote for each company that he or she represents, which is an obvious problem.
Fantastic. And Adrian, just touching on the power of attorney component there, you mentioned in terms of the rights in that regard. It's once you've got the power of attorney, it's an owner's corporation, strata managing agent's obligation to confirm if they've got authority to vote. What type of clauses do you see in a power of attorney document that would demonstrate they have voting rights at a general meeting, in fact?
Well, Paul, that's a great question, and there's two ways it's normally done. If the power of attorney has been properly drawn up, then it will contain a specific clause that allows the attorney to exercise voting rights on behalf of the owner at general meetings of that particular owner's corporation or a number of owners' corporations for strata schemes in which that owner owns lots. The other way it can be done is just by way of a general power of attorney, which gives the attorney the power to do anything the owner who provides the attorney that power could do. But in practice, it's going to prove difficult for strata managers and chairpeople of strata committees to examine what are legal documents and make an assessment as to whether the powers of attorney give the attorneys the right to vote at general meetings. So my suggestion is that it be made clear to owners, probably in meeting notices, that if they are going to send along their attorney to meetings, the attorney should provide the strata manager with a copy of the power of attorney document well in advance of the meeting so it can be properly considered, and if necessary, legal advice can be obtained about it to make sure that the attorney does in fact have voting rights.
Thank you, Adrian. Well, we're going to go on to financial management now because there's been some changes there. And these changes can be clarifications, and they associate the payment of levies. And one of them is obtaining quotes. So, Phil, I'm going to come to you because I think this is a governance element when we look at financial elements and levies along with best practices. Starting off with the first point there about the clarification of the rules on repayment of money between the administrative and capital works fund.
Yes, thank you, Paul. Look, I'm a big fan of this slide in terms of what it means, and also how it's set out. So thank you to our wonderful marketing team. But on the first bullet point, what it's effectively saying is that previously, if funds were transferred from the administrative or capital works fund to the other fund, there was an obligation to pay it back within 3 months. This was a historical rule. This new legislation allows for an owners corporation to make decisions in a general meeting as to what will happen if they have transferred funds. So my take on that is that it's conceivable that an owners corporation can resolve to not repay the fund from one to the other. In terms of the second bullet point, it's allowing an owners corporation to move quicker. So if a general meeting is held to raise a special levy for urgent repairs that were not budgeted for, previously that levy notice would have to allow for 30 days prior to it being due. Under the new legislation, if the purpose of that money is to mitigate something of serious nature, the funds can be payable within 14 days. So remembering earlier when we spoke about requisite notice and understanding that a general meeting is the only way you can raise levies, it does chop down the potential of a notice from about 23 days plus the 30 days down to a much shorter period where that money can be received. Now, the final point I think is quite a no-brainer. Under the new amendments to the legislation, if you're going to spend over $30,000, you have to get at least 2 independent quotes. And I mean, that's certainly best practice. And in addition to that, it's also a requirement for strata schemes, which theoretically have more money because large schemes have to do this already. What this part of the rules says is that now all strata schemes have to do it. So I think there's nothing wrong with wanting more than one quote for a lot of expenditure. And I think it's refreshing to see a really practical rule that allows every owners corporation and community scheme to have this in place. So that's my summary of financial management. I'm a fan.
Well, that's good to see. Best practice takes a logical and pragmatic practical approach, shall we say, in that regard. So it's wonderful. Thank you, Philip. Going to proceed on to the notices and record keeping. So there's a bit here in this regard. And Adrian, we've got notices and record keeping, and these are really associated with landlords' agents, and then also the changes to the schemes keeping records in electronic form. So there's some points there, and Adrian, I guess in a legal sense, covering all these scenarios, what is your sort of summary, shall we say, on the notices and record keeping?
Paul, there's always been a requirement under strata legislation for, firstly, landlords to notify owners corporations when they lease their lots, and for tenants to be provided with copies of the bylaws. What these changes are designed to do is make clearer who falls under the obligation to provide those documents and that information to owners corporations. And as we touched on earlier, what these changes now say is that if you're a landlord and you've employed a property agent to look after your leasing, then that property manager will fall under the obligation to provide the tenant with copies of the bylaws and a strata management statement if the building is a part strata building, and also provide the owners corporation with details of the tenancy. And this is specifically designed to increase the number of tenancy notices that are given to owners corporations, because as strata managers full well know, the rate at which tenancy notices are given is very low. I would estimate that probably in reality, only about 20 to 40%, and that's possibly being a bit charitable, of leases are actually notified to an owners corporation. Now, you might ask, the audience might say, well, what's the significance of that? Well, the significance is this, is that if the tenancy details are notified to the owners corporation, then the tenant automatically acquires some rights. So, for example, the tenant is entitled to attend general meetings of the owners corporation, whereas if the tenant's details are not recorded in the strata roll, no such right exists. So these are important things, and we'll see that the penultimate dot point on the slide indicates that tenants are now able to provide the tenancy notices to the owners corporation. So if there's a tenant who's motivated, wants to get involved in the affairs of an owner's corporation and attend meetings, then he or she will be able to provide the tenancy notice rather than relying on the landlord or rental agent to do so.
And in saying that, excuse me, in an operational sense and record keeping sense, it's now from the 11th of June this year. It's the way I read this, it's actually a requirement. It's mandatory to keep records in electronic form. There goes the days of certificate of title and all the paper on the desk. Some will say it's missed, some will say thank you, but it's taken a real lifestyle approach. It's all becoming online, and we've got to say goodbye to paper slowly. So we might see more sustainable process and function in strata management offices and owners corporations records keeping.
Paul, some would say we're moving into the 21st century, perhaps 24 years too late. But the important thing to note about this is that this will only apply to records, strata records, that are created after the 11th of June this year. So there's not going to be a mad rush for owners corps that have paper records to transfer them all to electronic format, although a lot have already, and CNG Property retain most of their records, if not all of them, electronically, which is really the way to do it these days. It's a lot more convenient, it's easy to find documents, and it just has so many advantages over paper.
Knock on wood there, I say I haven't had a paper cut in a fair few years here, so it's not too bad at all. So going on to the next part of the changes is two-lot schemes, and really touching on the notice to comply and matters requiring special resolutions. Adrian, we all understand how Section 146 requires a resolution of the committee to issue a notice to comply. But specifically for two-lot schemes, basically, I think you don't need a resolution as such in that regard if somebody has breached a bylaw. Is that your take on it?
That's right, Paul. So two-lot schemes are notorious for disputation and conflict, and in recognition of that, particularly where there can be a deadlock with two lots with equal unit entitlements, these changes to the legislation mean that one lot owner can authorise the issue of a notice to comply against the other owner without having to take that to a meeting of the owners' corporation and pass a resolution. Now, the workaround to that problem that has existed since time immemorial is for clever owners corporations to appoint astute strata managers like CNG Property, who are delegated the power to issue notices to comply in their agency agreement. And that is permissible under the legislation and avoids the need to have resolutions passed at general meetings to allow notices to comply with bylaws to be issued. But this deals with the scenario of a two-lot scheme where that doesn't apply because, for example, there might not be a strata manager or one who has that power. So this is an interesting change. And as I said earlier, it recognises the high level of disputes in two-lot schemes.
And would you say it's also prudent to ensure you've got the proper evidence before issuing the notice to comply? In that regard, making sure it's validated and cross-checked against the owners corporation's bylaws?
Absolutely, because the owners corporation needs to be satisfied that the bylaw has been breached before that notice is issued.
Thank you. And then in matters requiring a special resolution there, Adrian, it's the original owner, usually the developer, maintaining their full unit entitlements. That was obviously restricted. In simple terms, in a legal sense, what's your view on that?
Well, it really means that if the developer decides to hang on to one of the two lots in a smaller development, they'll still be able to exercise their full voting rights, whereas in larger developments, when the developer still holds at least 50% of the unit entitlements, the rule is that their voting rights are reduced by 2/3. So this is an interesting change. Whether it was necessary, I'm not so sure, but nevertheless, it certainly favours the interests of developers.
Thank you, Adrian. Now, I'm mindful we've got a lot of questions coming up. I want to just remind everyone that if we do not get to the questions, we will be directly issuing out the responses and advice, and also sending them with the slides and in our next newsletter. So rest assured, we will get all your questions answered, and I'm hoping we'll be able to answer their question via our panelists here. Moving on to the provisions of consolidation of bylaws. Now, I'd say I always thought it was a special resolution, Adrian, if you're consolidating bylaws, but they've made it clearer that a special resolution is still required.
This is an interesting one, Paul, because there has always been a need to pass a special resolution at a general meeting to make any changes to the bylaws. And since November 2016, whenever that occurs, there is a need to prepare a consolidated set of bylaws to record those changes on the real property register. And also since that time, there has been a requirement for every owners corporation to have in place a consolidated set of bylaws, even if they're not making any changes to the bylaws. I'm a little bit mystified as to why this amendment was introduced, because preparing a consolidated set of bylaws when there aren't any changes actually being made to the bylaws, in my view, ought not require a special resolution. It's not a particularly important decision. It's really a decision just to amalgamate various bits and pieces all over the place into the one document, which is essentially an administrative process. But nevertheless, the Parliament has seen fit to up the ante and require a decision on that issue to be made by a special resolution. And so that's the law we now deal with.
I was a bit sort of bemused by that, because I thought it was a special resolution, but I do recall when they introduced the Act, the 2015 Act, it was a provision that bylaws had to be consolidated. So, one would even say, why would we need to have a resolution to consolidate the bylaws? But it's interesting enough in that regard. And the second point here, Adrian, bylaws adhering to the Strata Schemes Management Act.
This is a really interesting one for a strata lawyer, because there was a view up until now that pre-existing bylaws had been grandfathered. So as long as they were valid bylaws under the old strata legislation, they continued to be valid and enforceable. Now, what this seems to be saying is that's not the case, and that if you had a bylaw that was valid under the old legislation, but which now conflicts with the new legislation, then it's no longer valid. And this gets back to the point we raised earlier. There is a need for every owners corporation to once again take a look at their bylaws and work out whether any of them are inconsistent with the Strata Schemes Management Act of 2015, because if they are, they're not worth the paper they're printed on.
And Phillip, in saying that, what's best practice when we're reviewing these bylaws? I mean, we see the legislation, we see the Act, we see model bylaws, etc. And we owners corporations can deal with many opinions from many owners and provisions in that regard. What's the best practice when you're looking at bylaws and making sure they adhere with the Act, regardless of when they were created?
That's a difficult question in fairness, because really to me it's more process driven. If an owners corporation has a set of rules, I think the fundamental thing they should establish first is that they understand what they mean. There's no point having bylaws if firstly the Strata Committee doesn't know what they mean or doesn't think that they're fit for purpose. I think firstly a committee can review the bylaws, but if there is a need to get advice, I would recommend that they then get expert advice to understand how their bylaws impact them and how they are impacted by changes to legislation. So I would say, in the first instance, an internal review, in the second instance, expert advice, and then that advice can be taken to the owners.
I think very sage opinion there. Thank you, Phillip. Now, just mindful of time, we've got managing agents and commissioner. I thought this one was interesting, so I'm going to put it to yourself, Phillip and Adrian, talking about transparency, talking about the commissioner at fair trading. You know what, Phillip, I'm going to get you to sort of start on the aspect of the notice of the contract, the expiration, and then I think I'd like to hear your opinion, Adrian, on point 2.
So thanks, Paul. I'll be brief. I'm conscious about time here. So in terms of the first point, there was already a requirement for a managing agent to provide notice of a contract that had 3 months left to run. Now, the new rules say 3 to 6 months in advance. In a practical sense, I don't quite comprehend the logic of that change, only because if someone says you have 3 to 6 months to do something, it's probable people might stick with the 3 months that they've already organize their businesses to deal with. But that said, the longer someone knows of something, it's better for the consumer. So I think that this change was an acknowledgement of consumer rights more than anything, to give more time for people to know when a contract would be coming to an expiration. In terms of the second point, I will refer to Adrian in a moment, but I think at this point, it's very interesting because my understanding to date was that when a compulsory agent was to be proposed through the process of tribunal, it would need to be suggested or recommended or proposed by either the applicant or the respondent to a matter. My understanding of this is that that has now been expanded to allowing fair trading to be involved in that process as well. But Adrian will know more than me on this.
This is an interesting one, and the position of the Commissioner for Fair Trading is fairly new. We have a Strata Commissioner now, and this is an entirely new power. My view is that given that individual lot owners have the right to apply to the tribunal for an order appointing a compulsory strata manager, which the tribunal won't do unless it can be demonstrated, generally speaking, that the building is dysfunctional. It will be a power that's used sparingly by the Commissioner, and I don't expect the Commissioner to be making many applications to the tribunal for the appointment of a compulsory manager. I think where the Commissioner will use this power is where you have instances of, for example, self-managed strata buildings where there's allegations of misappropriation of funds, serious meddling with trust funds, and no one really there to take the matter to the tribunal to have it sorted out by getting an independent compulsory strata manager appointed. I think that's probably where these powers are most likely to be used by the Commissioner.
Thank you, Adrian. I'm just mindful of time. We've got 2 minutes there and we've got a whole bundle of questions, and I just want to give a bit of peace to our attendees that we will be responding to these shortly after our webinar, both personally and also through the circulation after this. And this webinar is recorded and will be circulated too for distribution. Gentlemen, I want to thank you very much for attending today as panelists. I want to thank our attendees. We've really valued everyone's attendance. I'll just go back because I saw these interesting stats where the New South Wales government's forecasting that over 50% of people in Greater Sydney will live in strata schemes by 2040. So the great Aussie dream of having the Kingswood and the patch of lawn is really focusing in strata schemes these days. So it was some interesting data, and I thought, geez, there's a lot more construction and high rises to come around the Sydney. So I just wanted to share that with everyone, because when I saw that, I thought, oh, this is great information there. I want to thank you, gentlemen. Adrian Mueller, JF Co. Thank you so much for your attendance. Phillip Kooper, thank you very much. Head of Strata Governance there at CNG Property Group. To all our attendees, our owners, committee members, no, we've got a few strata managers. Thank you very much for attending. I hope you got a lot out of today's session. We will have the recording distributed, and wish everyone a wonderful evening. Thank you.
Thanks, Paul. Thank you, Adrian.
Thank you, everyone.
Bye-bye.